Great. Well, hi, everyone, and welcome. Very excited to see you all here on a very wet and cold London evening. I did not see any bloody horses running through the streets tonight. So that's always a good sign for London. I'm really excited to have everyone here today for this wonderful discussion from the UCL Faculty of Laws on regulatory models for algorithmic and AI assessments. It's safe to say that we've moved in the last few years from a period of time where we saw a lot of ethics principles around how to govern AI systems. And now we're moving into an era where we're seeing attempts to create regulatory controls and governance over AI technologies, both how they're developed, deployed, and in the ways in which they are maintained. I'm very excited to have a group of distinguished guests here today who are going to present to us on this topic and really talk us through some of the ways in which these different regulatory models are shaping up in different jurisdictions and some of the challenges that exist with them. To my left, I'm very excited to introduce Jennifer Cobbe, Dr. Jennifer Cobbe, who's an assistant professor in law and technology at the Faculty of Law at the University of Cambridge. She's the deputy director of the Center for Intellectual Property and Information Law and a fellow of the Lauderpact Center for International Law. Dr. Michael Veale, is an associate professor in digital rights and regulation and vice dean in education and innovation at UCL Faculty of Laws. He's a fellow at the Institute of Information Law at the University of Amsterdam, and he specializes in the tensions between law and policy and emerging technologies. And finally, Dr. Margot Kaminski is a professor at the University of Colorado Law School and the director of the Privacy Initiative at Silicon Flatirons. She specializes in the law of new technologies, focusing on information governance, privacy, and freedom of expression. Very excited of all of you in the room joining today. We also have many people joining online, and this event is being recorded. The agenda for today we'll start with some introductory remarks from each of our three panelists. We'll then move to a moderated Q&A discussion with some Q&A from the audience. So I will flag for those who do have questions, please write them down. You'll have the opportunity to ask them. We'll run mics to you. And for those joining remotely, I am trying to sort of monitor the Q&A on my phone, so we'll see how long this gets me. But if you do have questions, there should be a Q&A function you can see on your Zoom. Please feel free to use that, and I'll try to work those in throughout the evening, I should say. Gosh, already mixed up in time. Well, with no further ado, I'm going to hand over to our first presenter, Dr. Jennifer Cobbe.
Thanks very much, Andy. Thanks, Michael, for inviting me, and hello, everybody. I'm going to talk a little bit about risk in the context of the AI Act and GDPR. I'm not going to talk too much about risk because I suspect Margot is going to talk a lot more about risk. But I'm also going to talk then about another dimension to risk in this context, which is how particularly the kind of cloud providers who are running a lot of API AI services try to minimize their legal and regulatory risk by kind of offloading it to other people through their service agreements, and where that comes from and what kind of implications that might have for how we govern this kind of thing. And then I'm going to talk a little bit more about how identifying or managing or mitigating risk is extremely difficult, even though it's required by various laws like the AI Act and GDPR, why it's extremely difficult in the context of the supply chains through which AI systems are now often deployed. And then I'll finally have a little bit of a discussion about auditing, because that's a sort of a fundamental aspect of how people might begin to oversee some of this stuff. And I will hand over to Michael, the next speaker. So I think we have laws like GDPR and like the AI Act, which are heavily built around concepts of risk and risk management and identifying and mitigating risks that come up from new technologies, specifically things like AI, but also in the context of GDPR, other forms of personal data processing. And I think that should be understood in the broader context of the shift towards what we now have as being sort of risk societies, where risk is quite widely discussed and identified and mitigated. And again, that's something I suspect Margot might be talking a bit more about, so I'll not get into that. But one point to make about the way that these laws have been framed around the concept of risk and of identifying risk and of managing and mitigating risk is that there's very little talk in these laws about actual harm to people or about actual interference with their rights and with their interests, compared to the discussions in the laws or the requirements in the laws to do with risk. It is entirely possible to build a high-risk AI system as defined under the AI Act, with the various requirements of the AI Act for those systems being met, like having a good risk management system, like using appropriate data, and having good record keeping and documentation for your system, and opportunities for human intervention, and the various other things that the law requires. It's quite possible to have all of those things and still cause immense harm to people. And the law doesn't really capture that dynamic. And I think that's quite a big oversight in terms of the AI Act's approach to, in theory, protecting people or engendering trust in AI. Of course, there are also what the law calls kind of, well, or the law frames as being lower risk kinds of systems, which have far fewer obligations that apply to them. But again, they can also cause significant harm to people. There's very little in the way of objective criteria for determining which kind of systems cause which kind of risk in the AI Act, which makes it quite difficult to kind of understand how they've reached this classification of things of being unacceptable risk, high risk, to limited risk, and minimal risk. But none of those classifications correspond to the likelihood or the possibility that these systems could be used to cause actual harm, as I say. So I think that's potentially a problem. When it comes to general purpose AI systems in the AI Act, there are more obligations applying to those systems, things like ChatGPT and so on. There are more obligations applying to those systems, and there are requirements to identify when your system might be presenting a systemic risk. But the determination of systemic risk is framed largely around the floating point operations performed in training the model, and how many flops, as they're called, is the compute for training the model. I don't know what that has to do with risks, if I'm not the rights, and I don't know what it has to do with harm to anybody, so I don't know on what basis they could be described as systemic risk systems. It seems like the EU has, to use a very Irish phrase, completely lost the run of itself in writing this legislation, and I think that's a major divergence from any concept of risk, let alone actually something that would protect people from harm. I think there are a couple of implications of framing the law around risk in this way, one of which is that it hands a significant amount of discretion to the people who are building and deploying and using these systems to decide what is and what is not risky. Of course, in the AI Act, we do have these criteria of certain uses of systems. So, for example, like in employment or in immigration, for example. But beyond that, there's a huge amount of discretion. Also in GDPR, in data protection law, for people who are responsible nominally in law for what is happening with these systems, to essentially freestyle within the concept of risk and do lots of things which I think are unfortunate. So one of the problems we have with technology regulation in general is that we hand significant amounts of discretion over the meaning and effect of law to the people who were actually trying to regulate in the first place. You can see this in data protection law, where we ask people, or we require people, to take steps to identify and mitigate risks to people's fundamental rights and freedoms arising from what they're doing with their personal data. Now, of course, we have a whole regulatory oversight regime, but that's not fairly worth talking about in this country, so let's not get too hung up on that. What we have in practice is a situation in which these companies are themselves being asked to determine what the risks of their systems are, and asked to themselves determine how we might go identifying and mitigating and protecting people from harms of what they want to do. And that seems to be that we're putting the wrong people in charge of deciding what the risks of people are here, because if we want to regulate these companies, we probably shouldn't ask them to essentially decide for themselves what the law says and what it means in the context of their own processing. But we also see in their service agreements, and the way that digital technologies now are often used is in the context of a supply chain, where you integrate multiple different cloud services into one kind of complete application, and all of this kind of in theory works together, and that's kind of fine so far as it goes. But it does mean that all of this is governed primarily by the service agreements of the cloud providers, particularly Amazon, Microsoft, and Google, and their various subsidiaries and arms like affiliates like OpenAI and other companies, which are nominally independent, but really are now increasingly controlled by these companies. They use their service agreements to create asymmetries and legal rights and obligations between them and their customers. So, for example, they will essentially retain, so far as possible, all rights over the core aspects of the system that they need to control themselves, while disclaiming all potential liability to the extent that they can get away with that. Although there are, of course, then questions around unfair contract terms, but a lot of that is untested and unresolved. And delegating a lot then of other kind of obligations and other responsibilities to their customers. So they use these service agreements to offload risk in ways which I think are unfortunate from the point of view of people who want to try to rein in their practices, or might want to hold them to account for potential harms coming from their systems. So essentially what they do is they structure the legal regulatory regime to their advantage through these service agreements. And one of the primary ways they do that is by offloading risk to their customers and to users of their systems. And this isn't really captured at all by the way we've gone to regulate these things. So in data protection law, for example, you decide who has what responsibilities based on who is deciding the purposes and means of processing, which ultimately often comes down to the question of who is determining the purposes of processing. In the AI Act, we also have determined for non-general purpose systems which company should be responsible for those systems based on who is determining or specifying the purpose or modifying the purpose of these systems. But all of those questions about purpose of systems are separate questions to the risks that might come up in those questions, and are separate questions to who actually has the ability to modify, to produce, to amend, to update, to revise, and to mitigate risks in practice in this context. But like I say, these companies are very adept at offloading all of those obligations to, or all of those responsibilities as far as possible to other people. Which brings me to the question of auditing, which is one of the things that people have talked about as being a way of addressing some of these problems. People have talked in the past about there being an audit society that kind of comes to some degree with a risk society, in the extent that there's sort of auditing increasingly everywhere, not just obviously of AI systems, but in the financial sector, but also throughout huge aspects of society. Auditing kind of has developed as a way of smoothing financial markets and enabling them to work in the context of sort of modern capitalist political economy, with kind of roots and demands for accountability and control, but in many ways have ended up just being for major auditing companies in the middle of everything and giving them lots of power, which is, I think, a bit of a problem. But I would argue that I think in this context, AI auditing potentially risks a sort of a form of quite superficial kind of like de-risking in some sense, to enable people to use AI or to enable people to offer AI as a service without actually addressing the harms that might come from this. It's essentially saying that people will be able to have to, if they've undertaken certain checks, or if they've ensured that they comply with X, Y, and Z standards, or if they've done this with the data, or if they've provided this information to their customers or whatever else the particular auditing regime might require, then this thing is good, and this is great, and you can go up and use this. In theory, you should be able to trust the system. That's kind of what we're trying to get to with the regulatory framework, is where we can trust these systems. But that's not the same as a financial audit, where you go through people's books and look and see what they've been doing and determine whether or not you can trust them to invest in their company. It's not even necessarily the same as a quality audit, which does really exist elsewhere. In this context, we're not really assessing the quality of the system. We're kind of looking at the underlying processes. But we know with AI systems that they can produce new problems through their training, through their use, through their deployment, that are contextual. And because these problems are contextual, depending on where the system is being used and the context of it, like I said, the context of its use, it's extremely difficult to get any kind of guarantee or any kind of audit that would allow you to determine whether a system should be used or not. So I think there's a risk that we are sending with. I need to time that. Okay, I'm going to wrap up because we're the time. But I think there's a risk that potentially that the way the auditing regime in the context of the AI Act and the context of GDPR and the context of the regulatory regime more generally will function is to essentially superficially, as I say, de-risk these systems, to engender trust in using systems which ultimately are still extremely capable of causing quite severe harm to people and societies more generally, and leading people into a kind of false sense of security about whether or not it's appropriate to use this stuff or not. And I think that's kind of a problem from the point of view, of people who are interested in protecting people and societies from these systems. I would love to know what Michael and Margot think about this, but yeah, it's an issue. I think auditing has a purpose, but I think I don't want to say risk again, but it risks becoming sort of a plaster over quite severe problems and quite severe harms to people. Thank you.
You've identified the challenge we're going to have throughout this entire conversation of, will we say the word risk too much? I think there's a high chance that will occur. Thank you so much, Navarro. I think some really brilliant points to introduce around the sort of challenges of auditing and limitations of some of these models of assessment. I'm going to hand to Margot to offer your remarks.
So my discussion more than presentation is going to have the word risk all over it. Okay, so I want to try to move us just maybe, that was fantastic. Move us a little bit up a level and back a little bit chronologically to talk about why we're in the space of talking about risk regulation and AI to begin with. And to be clear, when I offer these thoughts, they're not necessarily my thoughts, they're the reasoning that's given for this particular regulatory design and this particular mode of regulation. So I'm going to start by asking, why are we doing risk regulation? I'm then going to ask a follow-on question of that, which is why this kind of risk regulation, because there's risk regulation and then there's risk regulation, and this is a particular flavor of it. And then I'm going to, within that, talk about delegation. So why is there so much delegation to private actors in risk regulation of AI? And I'll close by talking a little bit about some comparisons between what's happened in the EU and what's happening in the United States, towards suggesting that despite the fact that you all have law, well, not you all anymore, sorry, that the EU has law and the US, arguably largely doesn't, there's a convergence towards the US approach in a way that's it's distracting to have 458 pages of law that makes it look like something else is happening here. Okay, so first, why risk regulation? Well, in a lot of ways, it makes sense to use ex-ante systemic regulation to go after the harms that AI systems potentially are going to cause. So this is me adopting other people's arguments and some arguments I've made in the past, and I think even Michael's made in the past to drag into this. So first, I'm going to argue from sort of a negative standpoint, which is why it's really, really hard to use ex post individual rights to go after AI-created harms. So if you have an automated system or an AI system produces a decision that has serious effects that harms an individual, it's really hard for that person to know that they've been harmed, depending on what the situation is. It's really hard for them to access expertise to challenge whatever has happened in the system to cause them harm. And it's really hard for them to go up against, take the time and energy to go up against some enormous corporation with a really complex technology for harms that might cumulatively across society be incredibly impactful, but to that individual in a given moment might feel like smaller, less important things. So this is all the literature around notice fatigue, consent fatigue. We've heard this in data privacy, data protection before. And so a lot of folks, and this is the direction actually the US privacy literature is really trending in, are saying individual rights really don't work. We've got to do something else. And so why not make regulation more centralized, more top down in a certain sense? I'll get back to that in a second. And have it address the design of systems, because we know that building values into design is much more effective at creating systems that create fewer harms to people down the road. We can address scale that way by having this be ex ante. And we can get at, this one's a kind of important one, we can get around some of the obscurity of the technological obscurity of these systems by targeting the organizations and the people that are building them, right? So that's all the arguments for doing something that's ex ante and systemic. And in the context of, for example, data privacy, this leads to tools like the data protection impact assessment. One other really key point about this, it's not just that ex ante systemic regulation gets at harms at scale and potentially mitigates them before they happen. The other argument for it is that you can get at harms to groups and you can get at harms to communities by doing ex ante systemic regulation, where ex post responses don't necessarily get to the level of group harms. Okay, so that's the argument for ex ante systemic. So now there's risk regulation and there's risk regulation. Why does it look the way it does? I think I'll get to the sort of the political economy of that in just a second. But the sort of rational, ideal lawmaker sitting down and saying, we have this new technology, we potentially have some pacing problems, we've got expertise in the private sector, we don't have as much expertise in the government. They're going to start saying, okay, out of fear that we're going to put down the wrong standards, substantive standards, or out of fear that we're going to put down substantive standards that the technology is then going to evolve around and escape, so there's regulatory arbitrage, we're going to try to create a system where we delegate the benchmarks that we want people to mitigate against to either the private sector entirely or to some sort of technologically expert body that's going to be able to keep up with the changes in the technology. Maybe we'll embody some industry consensus, and it's going to come to us and say, like, here are your yardsticks. So that's the ideal, right? And that will hopefully evolve over time. The other reasons to have delegation goes to something that was already mentioned, which is this sort of fetishism around collaborative governance, which we see also in data protection, which says, you know, we can actually, if we have a strong enough regulatory mechanism, we can produce oversight over self-governance such that it actually will work. And in the data protection context, I actually think this argument is much stronger because you have a court of justice that's much more likely to step in and actually say, wait a second, this self-regulation thing is not working. You did a terrible job, like go back to the drawing board, Google, right? Okay, so there's risk regulation, there's risk regulation. What we're getting here is a softer form of law with a lot of delegation to the private sector or to standard setting organizations or various private sector proxies to say, come up with the things that you're going to measure, and then figure out ways to monitor yourself and to risk mitigate. And largely, I understand the AI Act as being about sitting there saying, we're going to eventually enforce. So like, watch out, at some point we're going to enforce. We can talk about perceptual conformity and how real that is. And so what you've created, though, is a circumstance where, again, going to the previous excellent presentation, most of the harms that you're asking companies to mitigate against, leave the safety harms aside for a second, are actually harms to individuals. But you haven't established any ex post way of challenging. Like when you read the AI Act and try to figure out if I'm an individual and I've actually been hurt by these systems, where do I go? You don't have a clear answer. If you look at what this is bleeding into my comparativist moment, you look at what the US has done, which is not law, it's guidelines coming out of NIST. They have the AI risk management framework, which actually has some pretty good stuff in there. It's soft law. It doesn't create a right of action for any individual. And again, you constantly see that the risks that are being mitigated against are things to what we would consider to be individualized human rights. So to me, this leaves this gaping hole in the system in the shape of an individual, and a second bigger sort of backstop question I wrote years ago in the context of another collaborative governance project / question about the importance of what are called penalty defaults, which is basically the idea that somebody's standing there, you know, with an axe saying, do this, like self-regulate yourself or else. And if you don't have some kind of penalty default in place, then like collaboration isn't collaboration, it is just self-regulation. Okay, I think that's a good place for me to stop.
Thank you so much, Margot. Yes, human-shaped hole in these laws is, I think, something that both you and Jennifer are kind of picking up on, perhaps a lack of modes of redress or any kind of meaningful enforcement functions in this. Michael, hand to you for the last set of comments.
Cool, thanks everyone. And it's always good to come last because you can, you know, build on everybody else's things that they were saying before. And I want to do it in a little bit of a different focus, maybe. When we think about algorithmic assessment or AI governance or similar, you know, all of us have worked, including Andrew, for a long time in just technology governance in different ways. And when you do that, you realize the world is just made of intermediaries. And really, you just see them everywhere. And you're like, it's intermediaries everywhere. It's always intermediaries. It's always platforms sometimes as well. And Jennifer's been writing about this for a very long time in cloud and AI, and I've been lucky enough more recently to write with her on some of these things. And these intermediaries are points of assessment, and they're points of responsibility, and they're points of responsibility and responsibilization as well, in all kinds of digital technology questions, and in AI the same, and algorithmic systems the same as well. And these particularly are emphasized in one area of algorithmic governance around open source models. Open source models, which people use that term, but maybe we can talk about code available or just broadly the models themselves as files being available, are a category of models that are difficult to reason about and are creating a lot of sort of political tension as well. These are pieces of software that are often very consequential, that have been trained, built, designed, and then often uploaded onto hosting intermediaries to first intermediary. But there are many before that, for example, the ones you trained the models on, the ones that collected the data for the models, the ones that have been involved in fine-tuning the systems potentially through as-a-service design systems that sometimes exist to design models down, the ones that produce software packs, which are often embedded within cloud infrastructures, and indeed the ones that you expect your users on your hosting service to later query this system on, improve, and deploy it. But hosting intermediaries are often ones that have a lot of responsibility placed on them because the stuff stays there for a little while, and they are the ones making it available. So just like in the copyright world, the ones who make it available are kind of the targets more than people who are just using it transiently or watching it or so on. You can go after the distributors, and the distributors are the case here. For AI systems, you find that there are sort of a few main distributors. The sort of main one in the industry is an actor called Hugging Face, an American-French company. There's also GitHub, which is owned by Microsoft, which is many of you will have used GitHub before, and that's a software repository designed for collaborative building of software. And they also host a few million AI repositories as well. And there are some newer, smaller actors like Civitai. Has anyone heard of Civitai? Some of you have, I think. If you have, you might not admit it. Civitai, which is mostly a home of horny teenagers who are making models that produce salubrious content of all kinds, or there's a risk of it anyway. These follows the general law that everything on the internet sort of converges on pornography, and indeed AI regulation does the same. So these software, the challenge with these repositories for assessment is that many of the models that are uploaded here may actually be illegal in many jurisdictions. For example, models that can quite trivially produce child sexual abuse imagery. Laws around child sexual abuse imagery in many jurisdictions are really broad and deliberately so. They don't come with a load of intent requirements, and they're designed so that software that can be software or technologies that can be transformed through a step into child sexual abuse material themselves count. You can't hide this in a password-protected zip file and then rub away the password and pretend you're not liable for this kind of content. In the same way, by analogy, in English law at least, it seems very difficult to make a model that is just a sentence away from producing very realistic child sexual abuse imagery and say, that wasn't child sexual abuse imagery. That's called a pseudo photograph under English law, and there's similar provisions in Scotland as well. And these technologies are caught by this in many cases because the laws are deliberately overbroad. And the same applies in the UK around terrorist content, where typically for those of you who are familiar with those kind of shenanigans in our jurisdiction, if the police can't find you've done nothing wrong but maybe suspect you're a terrorist, they look on your computer for a PDF of the Anarchist Cookbook, which is available from literal booksellers around the world. And they will arrest you on that and sometimes imprison you for owning this PDF, which I was just told the other day when talking to someone in the House of Lords about this. They were like, oh yeah, I used to have a copy of that when I was younger as well. Not to illustrate that Lords are criminals, but to illustrate this is a very widely distributed document, but that shows the overbroad nature of terrorist law in the UK. So the point is that when this is up there, if I send a request to these platforms and I say, hey, this model can produce child sexual abuse imagery, please take it down, which is generally the case under notice and takedown laws. And even in the US, I believe, I'm no expert on this, federal criminal law can pierce the kind of famous Section 230 and create liability for platforms. In this case, in terrorism and child sexual abuse are examples of those kind of laws, but I don't think it quite functions in the same way as the rest of the world for that. But the platform has to think, right? Is this claim correct? We've been told this model can do this, but we also know that people abuse reporting functionality all the time in trust and safety environments to send messages to try and get things taken down when they're not, or to try and deflag them, things like reputation management agencies, or indeed simply competitor AI companies who may not want competitor systems to be online. On top of this, you have the whole trust and safety world of content moderation that fits in much more to what Margot was saying about this kind of individualized rights and this disconnect, where systems that have sort of by design maybe could potentially produce harms that accrue to an individual are often prohibited by policies on these platforms. So Hugging Face, for example, do have a content policy which now incorporates models, and they're trying to work out under what conditions a model might be spewing hate speech or be discriminatory or be or so on, and to work out a guideline for when you don't use these. And this is related to an old set of cases around sort of issues rather around dual use technologies that have both beneficial and problematic or uses, or particularly in that word, military is often the dual and the dual use. But we find that these are often quite badly worded policies that don't fit the world of a tool, because the world of trust and safety and platforms moderating content that's on that platform is designed to fit the idea of a photo or a piece of text, and therefore doesn't often move as easily to that new world. And this creates a problem, I mean, particularly because there are maybe three kinds of reasons why you might take down a model. One, that it has an intention to do something, not the model itself, but the user or the developer said, we designed this to make medical diagnoses. It's quite easy to take down something on that ground because it's a stated intention, and you can then say, well, we don't have software that has that stated intention on there. So you look at the metadata. Software that has the potential to do something, well, that's actually an assessment task now. Is this functionality real? Can it produce child sexual imagery, child sexual abuse imagery, and how would we know? Or software that empirically has been documented to do something in the wild. Software that has been designed, in practice has spooked horses to bolt around. And we then know that might have happened, and we can then say a policy has taken could be made on that. But the last two, potential and actually observed, are really about evidence, they're about analysis, they're about research, very different from the normal world of platforms and intermediaries doing content moderation, where they're usually just outsourcing it to a cheap jurisdiction and letting someone go yes, no, yes, no, yes, no, getting a few out per minute. And those decisions are definitely superfluous and certainly not as considered as you'd need to be. And the automated tools for magic computer-driven assessment of these very open-ended systems do not seem to be arriving because the problems are open-ended and open-textured and societal and full of our own anxieties, and therefore are not really amenable to the kind of closing down, benchmarking, formalization, especially when you're generating text or images where the problems might be contextual. So this kind of leaves platforms in an odd situation for a few reasons, and I'm just going to close up now. So one of them is they are making these decisions based on, say, law. Someone says, I'd like to take down this, I'd like this to be taken down based on X or Y law, and the court is not really making this decision. The court is not involved in deciding how you would interpret whether child sexual abuse law or terrorist law applies here. And indeed, these things become quite hard to get to courts when you put the platforms in the way. It's not clear always the route in which a court would have a say on this takedown. And so this law never really gets clarified, and you get this kind of private jurisprudence that starts emerging on what is essentially a very, very complex issue. And you get a sublayer of pseudo-private jurisprudence when it comes to interpreting licenses. We see a lot of models actually using behavioral use licenses. These are a form of copyright license which say inside them, you should not distribute a versions model that disparages people, or that spews hateful content, or so on, or that is discriminatory. And these are terms that are often would be avoided in a company's own policy. But companies like Hugging Face are also enforcing these behavioral use licenses, which means they're enforcing someone else's rules, which is a bit problematic. But also will be forced to enforce them if this whole system ever takes off, of saying we're going to control this thing through licensing, because the rights holder can go and say, this version of my model breaches the license in X and Y way, and it's not self-evident that they do, and someone's got to make that call. Who makes the call? The platform. Now, do they just take down everything at all? Unclear. I think we might have a few ways forward here that take things away from the platforms. We have to think about externalizing this capacity. These are not like social media platforms of old. GitHub and Hugging Face are not hugely lucrative like Facebook. They're not user-focused. They're not full of advertising. They can't cross-subsidize to the extent that they can run gigantic content moderation bureaucracies. So they're not someone we can pile regulatory responsibility on, like the Online Safety Act, just because we feel like they're causing us anxiety. They're actually fairly modest-sized players. And we may get to a point, I would say, that there would be a presumption of taking down a model unless it meets certain criteria, like having been licensed or assessed externally, because the platforms themselves would feel that it's just too much effort to engage. So I've got other things, but I'll leave it there for the discussion. And I think there's a whole world of assessment around intermediaries, private governance that is unhappy.
Yeah, thank you so much, Michael. I've written down a lot of comments. I've written down one question, which we're going to come back to, which is what is a positive way forward? But we're going to do that at the very end. So we're going to do a positive note. Just a flag for those who are joining remotely, I am keeping track of questions. So if you have questions you want to ask in the Q&A, please do, and we'll get through it. We've got an hour ahead of time for questions, so we'll have some time to also take questions from those in the room. But I can tell, Margot, do you want to come in on a point that Michael's just touched on?
For a second, to kind of
You're still terrible.
no. So again, to bring us up to like common themes here. So one thing that struck me in listening to you is this. So a colleague and I have been talking about how law constructs technology, right? That really the game is not so much law trying to keep up with technology, which we know is not really accurate. Law sometimes can keep up with technology fantastically well by just saying like, here's a general standard or here's strict liability, we'll go comply with it. But this idea of construction of like, the AI Act is basically trying to figure out what is this thing that is AI. It's a complex, risky system. It's a complex, risky system that looks, as you've said in the past, like elevators, right? Which it doesn't. And so there's this misfit in that particular construction for exactly what you're talking about, which is this this existence of these intermediaries that are going to have to deal with basically being the platforms for the potentially harmful, risky systems or systems producing, content that invokes strict liability that the AI Act isn't even touching, right? Second point is just to emphasize, also something that came up in Jennifer's presentation, this central problem, we talked about the human-sized hole and everything, but there's also the central problem of quantification of things that cannot be quantified. So I just want to say that really explicitly. Risk regulation as a regulatory tool is about, it's actuarial by nature. It is about trying to measure things. And so if you, again, to fits and misfits, if you deploy this particular regulatory tool that is all about setting benchmarks and measuring things to try to get at harms that are actually societal or contextual in nature, there's going to be a major misfit there.
Yeah, I just really want to emphasize that point because one of the challenging things I think we're picking up here across all three talks is AI is a very difficult thing to regulate. We were talking about technology that is being deployed within products that are already been rolled out, a product of itself, a service, a piece of research. We're talking about a product with very short research to product timelines, a matter of weeks before something goes from archive or GitHub into a product with a complex supply chain of actors where different kinds of risks can originate and proliferate at very different stages of that supply chain. And we're talking about a technology that has a market that is widely consolidated by a few large actors. And I suppose with all that in mind, I'm just really struck by this point around risk. When we talk about what can be quantified and turned into a risk, where do we begin with that? How do we consider, if not sort of risk assessment or auditing or these other modes of kind of actuarial forms of assessing for certain risks, what other tools could be useful for trying to address some of these harder to quantify aspects?
I guess to sort of add on to the challenges of doing risk, is something I didn't mention before, is that when you produce and deploy things through a supply chain, if you're upstream in a supply chain, so you're actually, say, producing a system, and you have 20 million customers who are going to be downstream of you, perhaps 1, 2, 3 steps as well of other people beyond that, before the system's actually being used by somebody, you have literally no ability whatsoever to understand what the risk of that deployment might be, because it could be able to say 3, 4 steps down. But also, where that system is being deployed is going to be in the context of an application which is produced by compositing together lots of different services, which once they're composited together might present certain risks, which would be entirely unforeseeable to somebody 4 steps up the chain who has no way of knowing that that's how that application is going to be produced. The flip side of that is that the person compositing services together to produce an application also has no concept of what might happen when you bring these things together, because most applications have a fairly, probably a unique combination of services and a unique context and a unique use case to at least some degree. But they also, even if we have auditing, even if we have the requirements of the AI Act and of other laws, have very limited information about what happens when you take this system which is being specified for use at a general level and apply it to use in a very specific context. It's extremely difficult to take that kind of general kind of audit information or general documentation and put it to a specific context and understand what the implications that might be. So I don't know what the answer to this is, but it's even more complicated, I think, perhaps than we were even thinking about. So I think maybe, look, I'm not saying there's no role for risk in this place, but I think probably building a regulatory regime around risk is the wrong move. Unfortunately, it's the move that the EU has taken. They have at least taken a move in the UK, which has gone, well, regulators, good luck, which is equally, actually maybe even more unsatisfying, but I think this focus on risk and the idea that with auditing, we can understand these risks and appropriately manage them is just completely misguided and the fundamentally wrong basis on which to build regulation and stuff.
Now, I wonder about that point about a specific context and about the ways in which you can, this sort of complex supply chain just makes it very difficult to assess for these kinds of things. One of the examples that we've looked at are other sectors, and the sector of finance is an interesting one to look at, where in the US, the Consumer Financial Protection Bureau has explicitly tried to use some of its guidelines and regulation to change the design of technology, to say certain technologies that are unevaluatable for certain kinds of risk cannot be deployed. So that's kind of using regulation in a particular context to shape the design of appropriate technology can be used and to kind of push back against that frictionless sort of mass deployment of technology at scale. Is that an option that you think might be more appropriate to some of these contexts? Or do you again think that that's kind of going into territory where it just might be too difficult to assess for these types of sector-specific use cases?
I think part of the problem there is that if you applied that kind of standard, then you would have very few systems being used and deployed anywhere, because I think it would be extremely difficult to pass in almost any of the kind of, particularly the general purpose systems with that kind of standard. Not to say that it's necessarily, strictly speaking, impossible, but it's hard to imagine how a lot of them, particularly the API services, how they could possibly work under that kind of standard. It might be the case that what has happened is that these big technology companies have developed systems which are basically unworkable in practice and actually do cause potentially such significant risks that we can't possibly, or such significantly unforeseeable risks that we can't possibly do anything about them, and therefore have to take much more strict regulatory action against them, perhaps of that kind. There's nothing about these systems that means that they have to be used as they have been developed by these companies. It might just be the case that they've taken in their own commercial activities the wrong direction for the rest of us, and the rest of us need to redirect that. But I think it's possibly too early to say at this point, but that is a possibility.
I think so.
Yeah, so I'm going to take a maybe slightly less anti-risk stance, to the extent that it's a stance, and say that there's a lot here that really is about the specific design of these regulatory systems. So it's not that risk regulation could never work. It's that risk regulation, as it's envisioned in the AI Act, has some like fairly obvious gaping problems with it. Risk regulation, as envisioned in the United States, where it's soft law guidance, also has some very obvious gaping problems with it. So, for example, if you delegate all of your benchmarks to standard setting organizations, well, let me back up for a second. So a standard setting organization historically is, in the US at least, a private sector organization that might use some public sector like processes, but largely what it's trying to do is come up with standards that are going to address, for example, interoperability, right? That's why we have like plugs that fit in places, measurements, common measurements, and a common vocabulary for a sector to be communicating with each other. And like a lot of that stuff, it makes sense that the government doesn't do that, a private sector organization does that. And that's in part going back to the penalty default thing I was mentioning earlier, because like if your railroad crashes because you're like iron warped because you didn't have a quality control standard industry wide, there are going to be some really big negative consequences for you, whatever a regulator does, right? Here, you're passing off standardization to organizations in the area of fundamental rights to technocratic and technologically based organizations that are actually not the experts on fundamental rights. And they're used to doing like, you know, plugs and measurements and weights, and they're not used to doing like privacy, for example. So there, if you're going to do risk regulation around fundamental rights, the better place to be looking is international human rights organizations that have used human rights impact assessments for a long time, that know the problems, like the pros and cons of that particular type of assessment, and can talk about how you partner a human rights impact assessment with an understanding that you also have enforceable individual human rights on the ground. So it's all about institutional design. It's about trying to figure out, like, to whom are we allocating decision making, and what are the circumstances in which they have to make those decisions so that we can align them in some way with the public good.
On that, there's a chain of delegation really kind of can kicking that has happened. That you can look at it with the AI Act as a core example, but I think, as Margot says, you can see it echoed in a lot of other international instruments that are trying to adopt this model. Because algorithmic systems are really nothing more than a vehicle for our anxieties. We poured in a lot of actual worry about discrimination in decision making at scale, in faceless bureaucracies and so on, into the design regulation of these systems, because we've said, well, here's a point that we can now get to grips with, like, all of these issues we've cared about, but they've been so dispersed across society that now they're concentrated in software, so we can target them. Of course, they do more in the world, but I think they significantly are that. Because they've posed loads of big questions about distribution and about fairness and about treatment of people, humane treatment, but also dignity and so on. Legislators get uncomfortable with making firm standards around them, also because they don't want to be kicked out by their electorate in a world of culture wars. So they kind of put these broad, kind of statements around, oh, you've got to make sure it's not discriminatory, and if you've got multiple languages, it's got to treat those nicely, and all these kind of things. They get these broad words. And because those are not specific enough to be seen as economically cheap enough to implement at the world of small deployers that Jennifer was talking about, that they get past the standards bodies. And the promise of the standards body, which has been promising this since about the 1970s in European law, is that we make things cheap to implement and to comply with. So you don't have to read this complex law and interpret it. You actually just get this kind of guide that's much more, it's from your people. Your kind of people made this guide. It fits with the idea of how you work. You and the British Standards Institute or similar have come up with this stuff, and so it works with your workflow, and it's in your kind of language, not in legalese. But those standards bodies are, as Margot says, very uncomfortable dealing with issues like privacy or discrimination. So what are they going to do in practice? Well, they're going to make a process-based standard. Their standard for that part will not say you have to make sure that your discrimination metric in your kappa is below like 0.3, and if you're using this metric for ethnicity, then you shouldn't do that one. You should use. It's not going to get into that. It's just going to say, get some people, if you're lucky, if you want to, get some stakeholders, if you've got some spare budget. Go around and make some nice process. Here are some guides for the kind of meetings you could run. By the way, technical people would be nice to be involved. There are no technical tools. You should consider using the state of the art when you do this. And when you do that, write it up in a kind of form that's a bit blur. And therefore you will complete the standard, because then you'll deploy the mitigation that you've self-designed that we couldn't design for you because of standards bodies. We're going to do a cop out here and pass it on to you, the regulated entity. So regulated entity gets a standard, they're like, okay, the standard looks a bit like a law. Like the whole purpose of the standard was to make it clearer, and all you've done is just turn a legal test into standards language. In the process, there's been a very interesting legal transformation, which is often that the burden of proof have been reversed. Like if you apply the standard, it's very hard for a regulator to challenge that and to dig into this quality of the test, because you say, well, I just applied the standard. The standard told me to apply this test. I applied the test. And it's harder for a regulator to then go into the substance and say, did you apply that test well? Because if they do that, they're challenging the content of the standard, not the application of the standard. Because the standard's probably going to be poorly written in this regard. It's going to be, blur, and the company will say, well, we just applied blur. The legal requirement was not to do the test correctly. The legal requirement was to apply blur. And so challenge us, but challenging the standard is a really hard thing for a regulator to do. So the regulator's kind of stuck. The regulator either goes after the standards body, which requires you as a plucky little regulator to do something you've never really done before. The regulated entity can just sort of sail through without doing this properly. So when you look at who's actually making the law in this process, it's the regulator. The regulator is where the buck stops, where they have to say, has this process produced any results that are in line with the policy goals of stopping discrimination or reducing it in proportion to where it should be reduced in the part of the process? And so they are doing the sort of meta standard of like, our standard is discrimination is bad. We'll look at what's happened. And so, but that's, I think, legislators should have been doing to begin with. So we've ended up with that. The assessment, algorithmic assessment, is from the regulator in the ad, which is not even obliged to look into this stuff, really. So I think that's where we're going to end up, and it's going to be very tricky indeed.
You've had some people online compliment your rant on standards. Yes, which no, I think is very true. I think just to touch on a point and to draw on a question from the audience online, you mentioned discrimination law, and you mentioned this sort of ways in which these kinds of standards are applied. Christina Kolkoff asked, could we borrow from discrimination law and apply the reverse burden of proof as a way to move the weight off the shoulders of individuals in protecting and claiming their rights? And I think with this, I'll add another question, which is, crucial, I think, to this is understanding the impacts of these technologies in ways in which they're actually working in practice, or is the efficacy of the system actually there? And I think these are two perhaps ways in which other sectors like pharmaceuticals have tried to adopt a model that is trying to look at these questions. So I'm curious if that might be a different way of framing some of these risk assessment approaches that might be more fruitful.
There is on the EU a proposal, very early stages, for strict liability for providers of these systems, which isn't quite the same as kind of reversing the burden of proof, but it is a different way of beginning to look at these questions. It is like super early stage, it's not really going anywhere. But it's an interesting thought that we might need to really reconsider how we go about doing this thing. So I think that's, I don't know if it's the right answer, but it is perhaps worth thinking about as in terms of some of the providers, if the risks are, or the potential harms are so significantly unforeseeable because of the distribution model of this stuff, then perhaps something along the kind of lines you talk about could be a way forward.
Great.
Yeah, I have a quick response to that. So one of the projects that I'm working on, which is still in the middle stages, is about stakeholder participation in all of this. Impacted stakeholder participation, to be clear, different from stakeholder participation in the sense of private sector stakeholder participation. But a lot of these proposals, and Michael referenced this, suggest that the way that you solve this problem of immeasurable harms and the way that you make the harms more concrete is to involve individuals or their representatives from impacted communities or impacted groups, right? So one way you can involve them is at the level of risk assessment about a particular system. So you're building the system, you bring in representatives of communities that might experience harm from the system, and they say, this is the way in which it will harm me and my community, or this is the way in which it looks a-okay to me, go forward with it. Another way that you could do this is to have those stakeholders or their representatives participate in the standard setting, so that they're going to do this on a policy level. To say, okay, these are the types of systems that we watch out for, these are the types of uses, and you kind of force multiply it, so it's not just like every single new individual system as applied has to tax and fatigue the same people. Now, the last one I want to mention is that, interestingly, the NIST AI risk management framework contemplates a feedback loop and contemplates prioritizing in some way. Remember, this is soft law, so it's not ideal. Which contemplates prioritizing in some way external stakeholder input about the system malfunctioning in real life. And the idea is, if you're actually running risk assessment over the life of a system, and you're still running risk assessment when it's deployed, if somebody comes to you and says, this thing is breaking stuff, like it's breaking human rights, but it's breaking stuff, that should trigger something for the system deployer that's going to make them reassess their mitigation. This is also fuzzy, but like, reassess their mitigation, or if you're in the EU, like maybe gets a regulator to actually say, now is the time to try to recall the system or put a pause on the system's use until you go and fix this thing. So where I'm really skeptical of risk management ex ante with no evidence there yet, I think I'm cautiously hopeful that this is a way to potentially loop those kinds of harms back into a risk assessment process. The big problem, again, as Michael referenced, is that if you have if the game is all at standard setting and you get a presumption of conformity with the fact that you're complying with the standard, then it's not really clear to me how much a feedback loop is going to move you away from presumption of conformity.
Awesome. We're going to start opening questions from the audience. Get one here, one here. I think we need to get some mics, which I'm going to awkwardly run and do. But if those want to raise their hands, I will. Is this? There we go. Yep. Great.
Hi, good evening. Not sure if it's working. My name is Wojtek Buczynski. I'm an AI regulations researcher in Cambridge, and but first and foremost, I'm a financial services professional. So I sort of have two comments to all the fantastic points that you've made. So first of all, to put it like really top level, I hear a fair bit of criticism towards the AI regulation, particularly the EU AI Act, particularly from Professor Cobbe. And I don't disagree with any of it, but looking at it from like pragmatic and business perspective, it's a regulation for something that has never been regulated before. It's a regulation that industry and all of business has acknowledged that is needed. So I think that we can criticize what's not perfect about it, but to expect to get it very well, literally the first time around, could be perhaps a little idealistic. And I think that, the regulators over the past 3 years, and that has been extremely heavy delivery, that went smoothly, said no one ever about the EU AI Act. It's been 3 years, and for 1 second it was hanging in the balance, something that never happened in the EU regulatory history. So I would defend it a little bit. And for that point that again Professor Cobbe raised repeatedly about it being centered around risk, I think that it's risk as defined in business terms, not necessarily in terms of individual harms. And that's a language that businesses can understand. And perhaps one thing that maybe in my perspective you were slightly myopic about is that you focus very heavily on the EU AI, like all three of you, not any one of you, is that you focus very heavily on the EU AI Act, whereas I think that from my perspective as a researcher and a practitioner, it's actually more of a nebula of regulations. You have the Digital Markets Act, you have the AI Liability Act, which Professor Cobbe alluded to, which actually addresses that issue of liability, at least conceptually. And I'm not knowledgeable enough, but basically the presumption of guilt is on the platform and AI providers side.
I need to ask a question, if that's all right.
No, actually, I don't feel that I have to ask a question. It's more of a comment for you to respond to. And for Professor,
I'm going to stop you there because we need to get to other questions. So anyone respond to this comment about that?
A really quick response, which is just that one of the big problems with the AI Act is really that it's a deregulatory instrument, not a regulatory one. So it prevents member states from regulating anything other than the high-risk systems. It also can be used to strike down national law that regulates the development or use of AI systems in anything but the prescribed high-risk areas, and it will be used in that way by companies. It prevents regulatory experimentation at a national level. So you're right, it's hard to get things right the first time, but policy experimentation is totally precluded by the AI Act. So it means there can be no effective further development without proposals from the Commission. And the Commission chose a particularly old school regulatory instrument to do that. So I'm not really hopeful that regulatory experimentation is high on their agenda or capabilities.
But can I just come back on a very fair point he's raised, which is around the idea that liability is something that the EU seems to be taking up next. That might add in kind of more of these controls around, again, fixing this human-shaped hole. Would you agree with that?
Yeah, I think that was sort of passed in plenary in March. But I think the problem is the burden of proof is reversed if you show that a system has not complied with the essential requirements in the AI Act, which people have no visibility over because they're not the developers of the system. And so how as an individual are we meant to engage with proving anything at the design stage in order to achieve that burden of proof reversal? That makes no sense to me.
Okay. All right. Another question from the audience.
Thank you. Hi, my name is Francesca Mazzi. I'm a lecturer at Brunel University London. And I have 3 questions that I would like to ask you. So the first one is in relation to the EU AI Act and in relation to the fact that you mentioned that it's going to be impossible to measure and to prevent, to foresee the impact on people. And that there are no sufficient methods suggested in the regulation to do so. But I was wondering, what do you think about the fact that there are, first of all, 2 years that proved already very useful when it came to the GDPR, in order for businesses to develop some standards and some ways of measuring or creating an impact assessment tools. Second, the fact that even if it might be very difficult to have a clear line of all the stakeholders involved when it comes to the final product, not the initial AI developed by the programmer, you can still, theoretically, I'm assuming you can still probably involve people throughout the AI lifecycle for this purpose, because one of the main problems that are discussed is the fact that it will take jobs. This is one way in which it will give jobs, actually, to try to prevent, foresee, assess, monitor the impact of AI on the community. So I don't know, I think that this could be something to consider, even if, of course, it comes with challenges. It's the first regulation on AI. And the last point, it relates to the UK situation. I mean, I understand that maybe the EU regulation is not ideal, but the UK was the first one to actually come up with something based on risk when it comes to AI ethics with the Alan Turing framework. So the framework by the Alan Turing Institute. So I think they actually were the first, I mean, they were the first one to suggest it. They just didn't make it to the law. They didn't make it a legislation. Yes, maybe the EU took a step that could be risky to an extent, but what is the, I mean, what is the minus of making it to the law instead of suggesting it? Why is, I mean, it is aimed to provide more certainties rather than a higher standard, a higher way of creating a good AI society rather than the opposite. So I don't know why it should be seen as a not a good step. Thank you.
I guess a couple of points also to come up to what was said over here about, so two things, one of which was to do with the AI Act as being about business risk rather than being about individual harm. I think, I mean, that is my fundamental problem with it, that we're kind of building this regulation that is supposedly to engender trust in AI, that is supposedly to protect people's rights, that is supposedly to shine a path forward for AI regulation, and we framed it around essentially business risk rather than about actually protecting people and protecting societies from these things. So yes, that is how I see it, but that is my problem with it. You mentioned other legislation as well. We have things like the Digital Markets Act. A lot of the AI systems, if they're being produced and distributed through the provider's own system, so for example, if it's through Microsoft Azure and it's a Microsoft system being released through their own APIs and that kind of thing, that's not going to be covered by the Digital Markets Act. It's not going to be covered by the Digital Services Act either. It's really the AI Act and GDPR, and that's kind of it. So the EU has built these whole new frameworks in the DSA and in the DMA that are supposedly to regulate digital services and are supposedly to govern these sort of gatekeepers and these intermediaries. But to a large extent, the way that AI systems being produced and developed and deployed or being offered as services are not intermediaries and they're not gatekeepers under the definitions provided in the law. So this new regulation largely doesn't apply to the kind of stuff that I'm talking about. And just to come quickly to the point of the AI lifecycle and whether we can have different people monitoring things across the whole the whole spectrum of it. Part of the problem with AI services is that the AI lifecycle becomes distributed between multiple different actors. It's not one company producing and deploying and using a system. It's one company in charge of producing a system, which is also using services, data labeling or whatever else, or content moderation provided by another company. The system's then being deployed by a third company, or a fourth company, or a fifth company, or a sixth company, depending on what it is. And then you have perhaps another company or another person at the far end using this system. So the question of exactly how you would go about bringing people in to monitor right across the life cycle is extremely difficult because there's no coherent life cycle anymore at that point. There are lots of different people doing lots of different things with different aspects of the system, and that's very hard to monitor. I think that's a real challenge in this case.
I think, and related to that point that you made when we were writing the supply chain space, is that the exact structure is also different every time it's called. So when you're calling an API, you have no guarantee that the same companies or actors are being called compared to when you called it 10 seconds before, which I think is very enlightening. And I think also in relation to why the AI Act may be a negative, because it does crystallize as a regulatory choice, it crystallizes and incorrectly crystallizes AI as a product or even a service. And it says, this is how we regulate it. We understand it this way. And it is the only way we regulate in the EU because it precludes other regulation. And that is the wrong direction. There's an incorrect direction to go down. And so we crystallize it and basically pretend it's something it's not, which is an unproductive direction, and actually stop member states from making any law which says anything other than that, because you can strike it down under maximum harmonization. So that's why it's not productive. It's not an addition, it's actually a takeaway from that.
Margot.
I'm going to try to be relatively brief. I don't hate the EU AI Act. I think that there are a lot of things in the EU AI Act that I, as an American, look at and go, gee, I wish we had these. So, for example, the fact that there are actually types of systems or uses of systems that are banned is extraordinary. There's a threat there that there's a possibility that new systems will end up being banned, or new uses of systems will end up being categorized as high risk somewhere down the line. That's really important also. I think that the huge amount of work that's going to go into reporting and recording many different types of currently opaque decisions, and then potentially making those pieces of information subject to regulatory inspection is a huge deal. And the contemplation of post-market mechanisms, which really rarely get a ton of love or attention, with the idea that post-market mechanisms could result in recalls, I think is really exciting. Okay, that said, there are all these ways in which I think that the act as a piece of institutional designing gets in its own way in terms of trying to make those parts effective. Not the least of which is delegation to standard setting organizations, and then presumption of conformity once you comply with those standard setting organizations' standards. And there's also, just going again high up for a second, if you're thinking about one of the justifications for impact assessments in any area of the law is that they're supposed to be step one of potentially a later type of regulation. It's delegating to the private sector to do its own risk assessment, find out what the harms are, come up with ways of solving those harms, with the idea that later on a regulator is going to step in and say, great, we've coalesced around what the harms are, how to measure them, and how to fix them. But the AI Act gets in its own way of trying to let those impact assessment processes bubble up eventually into actual hard law, in a way that I think is just poor regulatory design. So I hope that's helpful in clarifying my not entirely hating on the EU AI Act.
Okay, I'm starting to keep a queue. So we've got this gentleman here, the gentleman in the suits. I believe I saw you next, then we'll take these two.
You're welcome for participating in this heavily, more than an hour into this, and having a conversation about risk. So this is
what we'll do, by the way, if those who have the microphone could pass it to the next person, they'll get another one going as you're talking, so we can kind of keep them on either side of the room. And if you do have a question, I'll try to take a few of them at a time, but please.
Hi, I've really enjoyed the conversation tonight, thanks. So I'm Wayne Holmes, I'm an associate professor in the Institute of Education of UCL, and I've been involved in researching a critical approach to AI and education for at least a decade, long before all of these experts popped out in the past year or so. As part of my work, I'm involved with the Council of Europe. Now, for those of you who don't know, the Council of Europe is very different to the EU. It's twice as big as the EU in terms of member states. It's the human rights organization for Europe, and its remit is about human rights, democracy, and the rule of law. Back in September of last year, the 46 ministers of education instructed the Council of Europe to develop, and I'll try and get the language right, a legal instrument to regulate the use of AI in educational settings. And I'm part of the team that's meant to be advising this, but I'm not a lawyer or any legal expertise at all. But what I'm interested in is, the argument we've been making from a kind of a common sense approach is that the world of medicine for many, many years has worked very well. I mean, there's always problems all the time, but nevertheless, before a drug can be prescribed and used, it goes through a testing process to check two things. One, does it do what it says it does? And two, is it safe in so doing? And so the logic we've been pushing, apart from the AI and the education context itself, is that we really should be thinking about the AI tools that are being proposed, and there are thousands of them for use in educational context, that they too should have this this pressure upon them, or this requirement that they have to demonstrate their efficacy and their safety. So my question to the panel is, what advice can you give me? What logic, what push can I do to ensure that the approach to the Council of Europe is effective to protect children and other learners across Europe?
Okay, great question on safety and efficacy. Someone want to take this, Margot?
Super quick. So I'm not an expert in education. I work in education. So a couple of quick things. What you're describing is still risk regulation, but a more precautionary approach. So this is, again, my point that there's risk regulation, and there's risk regulation, right? And there's risk regulation that years ago, Andrew Tutt, who's a US academic, called for an FDA for algorithms, like a Food and Drug Administration for algorithms and for a licensing regime. Frank Pasquale and Gian Claudio Malgieri have called for something like a light touch licensing regime. So like you're not out of step with that at all. Then there's, contrast, an enterprise risk management form of risk management, which is like task it to the companies to do their own risk management and try to not get in trouble. So a more precautionary form of risk management that looks more like licensing, great, specifically in high stakes standards like education. And then the second thing I'd say is that there's a lot of hand waving around individual rights of appeal that really make a lot more sense in a lot of educational settings where, if there's a significant decision that's going to affect somebody in a way that damages their future, you might think about trying to put in place ways in which that person can contest those decisions. And there's rights to contest significant AI decisions floating up in a whole bunch of norm setting areas, including my understanding is in the Council of Europe.
So we've done some work on EdTech and law and AI here at Laws, and one of the things to bear in mind is just schools are very easily captured by technology companies, and the focus on efficacy should not be isolated to those tools either in vitro or in RCTs or something like that, but have to look at how those tools are designed to recalibrate the role of teachers is basically sort of plug and play. They're just designing and becoming funding streams for intermediaries, or indeed a much longer train of training kids using these free platforms like Microsoft Basics, Google platforms which they provide for free to schools in order to get those kids as product users later in life. And so unless you look over this whole life cycle of where the kid is going and where the value is actually being accrued, or where these individual AI tools actually lock you into certain kinds of LMSs and certain kinds of other hardware and software, it's very hard to talk about efficacy because you're just sort of looking at a piece of jigsaw rather than the rest of it. And so you've got to zoom out for political autonomy, which I'd say would be something the Council of Europe doesn't know how to do, but could be taught.
Yeah, just to stay in this for one quick second, because I think we're touching on something we've talked a bit about, which is around, in a way, to do that model of efficacy testing requires another intermediary to conduct some kind of RCT or a phase 1 drug trial or a PRO of an EdTech platform and its efficacy and safety. Can I ask, are there models of third-party assessments that we can look at that offer a sort of good or ideal model that kind of avoids some of these issues of regulatory arbitrage or capture, or sort of a few small companies kind of taking over that place? Are there infrastructure or tactics you can put in place to mitigate some of that?
I don't think so, because I think it's the speed and kind of programmable infrastructure speed of IT. We've just seen it fails all the time in IT procurement. Like someone promises the world, or a post office like billing system, and end up create a capture contract, and lots of people end up in jail. And so they're not the right people. And so this kind of structure, I think, is we failed in the place where we might find it. We might go, maybe IT procurement would have some cool models for this. And then you look at it, it's just like a dumpster fire and decor. Maybe not, maybe we'll look somewhere else. So it's up to us to design them, I think.
As a big picture response to this, a huge amount of this kind of third party delegation, it can work better when you have settings where there are longstanding players, there are repeat players, there's been professionalization, and something has been used to a point where you actually build up standards. And so perversely, you end up with regulators who think, okay, it's better to rely on this delegation at the early stages of development and use, because that's going to let us make these hard decisions later, where it's actually better to do that kind of delegation when you have a professionalized community that has some norms and has they're not going to go disappear into the night. that doesn't answer your question, but absolutely right then.
Okay, we've got about 15 minutes left. I'd like to take a few questions at a time because I see a lot of hands going up. So could we do 3 questions? If we can keep comments short. Gentleman in the suits, we'll do you in the front with black. I believe it was you in the brown next, and then we'll take 3 more.
Yeah, I've been running a think tank on civilization transition to the time where we will be coexisting, hopefully with a beneficial or benevolent AI. So I look from slightly different perspective, but I recognize the same problems. There are 3 problems, and I propose I identify 3 problems, and I provide 3 solutions. So I wonder if the panel agrees with that. The first problem is that the regulatory level works at a linear pace, whereas AI develops almost exponential pace. So you every 2 years or so, you double the gap. The second thing is, and this is the most profound thing, that I really am astounded that so few people mention this, that AI is no longer a tool. It's a new type of intelligence with all the consequences for us. And the third one is that what's the purpose of assessing the algorithms where we already know that those who developed ChatGPT didn't know in the end why it is capable of what it is doing now. In a few days' time, we will be having GPT-5. Do you think that these people know how it will be working? No. There is a red team there, right, which is assessing it, but this is the best guess, and we have to be humble and accept that. So what is the solution in my view? The first one is to take the example of something that has worked. And this is the W3C committee on controlling the internet. There are only 420 people doing a magnificent job. So it is doable. The result or the conclusion is leave it in the private hands, in the sector. I know that this raises eyebrows. What? The industry will control itself, but it can do it. There is a partnership on AI in America. There is the Frontier Forum assigned, and Americans work much faster and much more confidently than EU. I was participating in that AI consultation, and it has done a great job. It has improved tremendously over the 5 years.
Okay,
so the final point,
okay.
So that's the final solution is open sourcing, as Professor Margot mentioned, that let the sector do as much as possible to control itself with the guidance and guardians of the state.
Okay. So we've got a pace about AI, about the ways of potentially regulating by giving more power to private industry. Would you like to chime in?
Okay, my name is Victoria. I'm a practicing solicitor, and I'm a student for LLM in University of London, and I study fintech law and regulation. I see everybody here is very learned, and I'm also a professor, but in something else, but everybody here is very high level, and it is very difficult subject, obviously. So my question is, so when I was listening to you, I did understand from Professor Kaminski that it would be advisable to consult with, in your opinion, with organizations for international human rights. But my general question to this panel, I mean, I'm getting what is the wrong and the not okay thing. But the question is, could you summarize in simple words for students? I'm sure there are other students here, and I'm not just the only student here. In simple words, what would be the right thing? How it should have been approached? That how, from the very beginning, let's suppose that this wrong thing does not exist. So if you could summarize in simple terms, so it will help us kind of to learn how we could think about that.
Okay, so a question about sort of what alternatives might there be? With you in the brown, handing out a microphone. Thanks.
Sorry, my name is Catherine. I'm a solicitor working in the pharma space, so also not involved in this area, but also a highly regulated area. Margot, you said that the EU AI Act doesn't seem to cater or provide a means for enforcement by individuals, I think. I'm not sure if I got that right. When some of the risks you've described, you know, I think some of them are already covered, or most of them actually are already covered by existing laws like consumer protection laws, GDPR, Equalities Act, tort, etc. So I'm wondering, is the idea actually that the process of distributing or developing these programs is regulated under the Act, but actually enforcement by individuals would be via these other laws? And then one other quick point, these risks are known and addressed currently. So why does AI need this additional law? And if it's because there are unknown risks, which seems to be the case, how can you assess for them if they're not known?
Okay, very good question. So I've got three, sort of this question about the future or alternative ways of regulating this, kind of by more of a private sector model. A question about what other models beyond risk might there be to regulate. That's also something a few people online asked. And then two questions around the powers of what can be regulated and what additional, why have additional law for assessing unknown risks.
I think to come to the question that was the last question about the known risks, the other possible risks, I think part of the problem we have is that, yes, there are kind of known risks of AI in the abstract. We know about risks like discrimination, we know about risks like privacy risks or data protection harms or whatever else, but it's very difficult to understand and foresee and understand risks in specific applications and specific use cases and in actual individual uses. The foreseeability here is a real problem, particularly in the context of the supply chains through which these systems are likely or mostly going to be distributed and then integrated into applications and used. If we have, for example, tort law, in theory, we could, sue for damages where there's been some kind of harm caused in principle, but where those harms are largely unforeseeable. And where, for example, a company might say, well, we couldn't possibly have foreseen this, but also we've been audited by this company and look, taken all the steps we possibly could have to address the risks from this system. It's difficult to see what kind of action you might have under tort law to address those kind of problems. And a similar kind of thing comes up with other areas of law where it's not exactly clear. Something like discrimination is much, if it's direct discrimination, much easier potentially to show. But you would also then need to show that the same system is treating lots of other people in particular ways or in a different way on the basis of a protected characteristic, which again, because these things are distributed and used across multiple different applications in lots of different contexts, is extremely difficult to show. So again, you have the same kind of problem of not just being able to foresee a problem, but also then being able to show that this was something that should have been accounted for or could have been accounted for in any way. And I think that's the point at which existing laws begin to fall apart, is with the model of production and distribution of these systems. And that's the point at which I think we need to bring in regulatory frameworks and other mechanisms to try to address that falling apart. Because if we don't, we're going to end up with lots of laws that in theory apply to this, but in practice are kind of not very much at all.
Margot, Michael?
I wish I had the magic, this is how AI law should look answer for you. I think that the concern that I have, and this relates to the tort law question also, is that this is cart before the horse, right? In the sense that tort law, and I'm not a tort law scholar, largely is about duties of care. I'm definitely not a European tort law scholar. I get to really keep myself out of danger there. But it's largely about duties of care. And here we have a massive piece of law that is trying to say, these are your duties of care, right? And so there's no way in which passing this law first isn't going to in some way communicate with or influence what the duties of care are going to be when you're talking about tort. The second point on this is that, like 6 or 7 years ago, I tried to outline the various categories of harm for automated decision-making. And I described it as being basically 3 different types of concerns about automated systems. The first is an instrumentalist concern of trying to make sure that the systems are producing accurate answers, which we know they don't always do. The second is a justificatory concern in being concerned that you're using opaque systems to produce decisions that are really significant. And there's all kinds of reasons why we don't want particularly opaque decision-making, including trying to check for the way societal values are being embodied in that decision-making. And then the third was an autonomy/dignitary concern, which really sounds a lot like concerns in data protection law, which is about essentially having decisions made about you by a system that disrespects your autonomy as an individual human being, where a human decision maker who contextualizes decisions and can be challenged fails to objectify you in the same way that an autonomous system would. So those are the kinds of concerns. I'm not saying each of them are equally weighty, nor that I think that they're all ones that the AI Act is trying to solve. But I'll say that like a lot of those types of harms are harms that you get at through individual challenges and not harms that you get at through ex ante lumping together of human rights into a risk assessment.
Okay, super quickly on this. I mean, just on the points at the back, I think in terms of exponential growth and new intelligence, that's predominantly marketing. And you find people in industry do agree with this quite significantly. But on the last point there, we constantly regulate things we don't understand. Most drugs, we have no idea about the mechanisms of working. We have no idea how they do the things they do in the body, why they do the things they do in the body. We only observe outcomes, side effects, and so on. So this is totally normal for regulation. It's totally normal for legislation. It's totally normal to do. I mean, people just don't understand paracetamol. I mean, maybe it doesn't work at all, but they definitely don't understand the mechanisms of functioning of many parts of commonly used drugs. And I would push back against sort of idolizing things like W3C, which is effectively just have to follow whatever Google Chrome does these days. So it's not exactly a regulatory forum. It doesn't actually make decisions anymore. Or the partnership on AI, which more or less collapsed when companies withdrew money from it. Was anyway more or less a home for people during the Trump administration so that they could have a job and run away from the White House Science Technology Office and then come back after the weather was clear. In terms of what would the right thing to be, I think there's a right framework to look at, which is when you deal with the political economy of the issue, you start to say, okay, analysis can happen. You can assess things. You are not deploying technologies without having these issues externalized onto those players and communities. At the moment, supply chains are being structured so that the actors who are closest to the ground and closest to the harms and impacts have no real capacity to do this and have no agency over the systems they're deploying. Regulation that targets that attempt to structure a value chain where maximum value can be extracted with minimal responsibility falling on the intermediaries is the thing that needs to be solved foremost in AI, because AI is not about clever technologies. It is a way of reshaping decision points in the world to extract value. That is the predominant function of what's going on here. And most of the rest is some cool software and marketing. Those are the powers at play. And if we tackle those firmly, we can start to then deal with the other remnant issues, which are real, from bias, discrimination, transparency, and so on, but are not actually the core of what's changing in society now.
Okay, some cool software, some technology. I'm going to take two final questions, more of time. So this is the final two. So I've got the gentleman on the left in the very back with the microphone, and then the gentleman in the very back here with the gray suits.
Yeah, thanks for a very interesting discussion. I wanted to ask about the political economy of this. Margot, you talked about how the risk-based approach is not without merit, but at the same time, the whole general direction here isn't getting a lot of love. And it seems like it gives a lot of power to private actors who, have had these decisions delegated to them. So my question is, and also building off what Andrew said about markets being concentrated, to what extent has the political economy shaped the AI Act as kind of a tool to delegate power to these actors?
Okay. So how's the AI Act shapes the political economy of this space? Is that might get that right?
Yeah, like the reciprocal relationship.
Yeah. Okay, perfect. And then get your question.
Well, first, let me thank you for your time. I need to apologise for arriving late. I apologise to the panel and the organisers, who also thank for the invitation. This is, you may have covered this in previous explanations, but repeat it. I'll reduce the level of details as well, but nevertheless. Can a statute be transposed into an algorithmic logic, be interpreted by a conflicting culture? Can that conflicting culture translation be proven by applying the same logic to the statute?
Okay. Final two questions, and we'll do final remarks. Anyone want to take those two?
Can we reverse engineer those?
I think there's an extent to which the AI Act has been written in a way which reflects the concentration of compute around about mainly three companies, but some sort of smaller players and some sort of hangers on. Particularly the way the Act was originally written before the generative AI stuff kind of got bolted on at the end in sort of some haphazard fashion. The original idea that you would have a provider of an AI system which would determine the purpose of it and do all the kind of like conformity, that kind of thing. I think that was broadly reflecting the point at that time at which 3 companies, 4 companies, whatever it was, were kind of the main ones. And okay, we can make them responsible and then we can govern what happens after that. The way they've gone about doing that, I don't think works for the various reasons that I've talked about. But I think there was a recognition that there were a relatively small number of providers that they could potentially apply particular obligations and responsibilities to, and that might help address the problem that they saw with AI. I think that's the EU said similar things themselves in terms of, or implied similar things themselves, where a lot of the law, a lot of the discussion around the law, a lot of the speech around the law was about, you know, reining in the sort of big American companies. That was obviously a motivation for this, and it was obviously a motivation to kind of put obligations around these companies. And then we could have European companies that could come up and like also meet those obligations, and that could be great and everybody would be happy. But I think what happens is that the political economic dynamics here are that with the supply chains, with the way that the companies structure their relationships with others, is that they're not just structuring a supply chain, but they're structuring through their terms of service, through their practices and so on. They're structuring the kind of whole regulatory environment in practice as it works in practice. They're making normative claims about laws' meaning and laws, and as a result, having a significant impact on laws' effect in these supply chains, and therefore they are themselves regulatory actors, not as just as companies being regulated, but they are themselves as, you know, exercising regulatory power over other people in these things. And I think that is a symbiotic kind of thing, if that makes sense, whereby the law was written in a particular way to some degree at least capture these big companies. But the way that these big companies operate, the way that they work their services and they work their service agreements, is to take what the law is kind of doing, and it's the same with other aspects of law, and try to shape them to their benefit and to try to determine what these laws actually mean in practice. And that kind of is working both ways, I think.
I think the hilarious thing about the AI Act, in exact relation to what Jennifer said, is that the Commission believed that these few companies would be the ones purposing the high-risk systems. They just completely misunderstood the industry and all the signs that were there that these would continue to want to be intermediaries, and they would move the risk just to tiny EU SMEs who are going to take all the kind of compliance burden and become the sort of liability crumple zones at the end of the pipeline. And so they thought they were going in boldly to attack big tech, and like you look at it, you like literally they're just going to pull the rug out under you and say, oh, we're just making the underlying services. By the way, that's the much less risky and cooler thing to do, and we don't know how to think about context anymore. We just scale using automated tools. I'll give a quick point to the question about law. I think, you know, turning law into code is a very risky thing because law is designed often to introduce friction and exactly points of assessment, and often it misunderstands that you know, law is contested, law is deliberately open, and law is not static, and that's exactly what helps law keep up with technology. And if you ossify it into a sort of algorithmic system, whether or not that's being read by an LLM or something else, then you lose the exact benefits of the technology that is law, which we should build on. And there are obviously more formulaic areas of law which might be good to codify, like the tax code parts of it. You know, it would be good if it wasn't like constantly adding friction where we decide societally we don't want that friction, it's not valuable. But we have to have a discussion about where friction is valuable and productive, and law has many points where friction is deliberately meant to be productive and is.
I'm going to end with a comment about the EU AI Act and friction, which I think is speaking to the political economy of this. Like, it's a done deal. It exists now, right? Did it reflect political economy? Yeah. Did it reflect the political economy of the various big actors? Yes, of course, right? I think that the bolted on afterwards general purpose AI system stuff is a great example of that.
And bolted is a very strong word. Blue tacked on, isn't it? Like it's
the gum my daughter's mentioned. And I think now the game is trying to figure out to chase where the substantive standards are being made. And so this involves, figuring out ways to participate as standard setting organizations, figuring out ways to participate in conformity assessments, figuring out ways to participate in fundamental rights impact assessments, figuring out ways to go to market surveillance authorities. And we were talking about this and try to figure out, how does a member state market surveillance authority take complaints? So I don't think it's over. And I don't think things are hopeless. I think that it's really about being attentive to what institutional designs have been put into place to thwart effective regulation and trying to figure out how one routes around / uses counter norms formed in counter institutions like the Council of Europe to try to bring those norms into a system that we're maybe not super satisfied with.
Okay, I want us to end on one final question because we're already over time. So as you mentioned, Margot, we are no longer in this country a part of the EU. We are moving forward and we'll soon have potentially new governments in power in November of 2024. The government here said they're going to take a sectoral-based approach to regulation. We understand that within the Department of Science, Innovation and Technology, there's a lot of work going underway into a proposed bill that will likely come in 2025. What should they do differently? This seems like a moment here in the UK in which you can learn from the lessons of the EU and try to take a different tact if you're an optimist like I am. So what would you say to them to do differently if you were to try to restructure a bill for the UK looking at?
I think I agree with Michael. A lot of the regulation needs to be focused at particularly the relationship between the major AI providers and their customers and the various other downstream actors in supply chains, but also up the supply chain to the various other companies that these providers interact with or themselves depend on for various aspects of producing these systems. I think those kind of relationships either side of the providers are the key points at which we should be putting obligations on. The service agreements of providers are one of the key mechanisms by which they set about structuring sort of all of the downstream supply chains, and that's something that I think we need a much greater focus on. And then upstream, as they kind of engage in really quite extensive kind of regulatory arbitrage, kind of playing off different jurisdictions against each other. I think we need to have various kind of obligations, requirements, and restrictions on exactly what kinds of thing they're doing at that kind of production level. So, for example, it simply shouldn't be the case that an AI producing company can outsource all of their data labeling and content moderation and all of the data production to some country with far weaker privacy or data protection laws and just completely bypass the protections that apply here or elsewhere. That's like an obvious win that should have been in the AI Act, but isn't, but could be in law in the UK. So I think we have some directions, but those two key external kind of interactions between the providers or the producers, as you might call them, and the customers on their sort of their own kind of supply chains. I think those are the key things, not so much focusing on risk and that kind of thing, although of course fine if we want to have some risky kind of regulation stuff in there, some auditing kind of obligations in there, but those two key kind of exchanges, because you're really exchanging control over different aspects of what used to be called the AI life cycle, but as I said before, it's not really a thing, a coherent thing anymore, but you're exchanging control over different aspects of the life cycle through those agreements and through those different relationships, and that's where I think we need to be focusing regulation.
I think I agree with all of that. I'd add as well that a perspective that DCIT is what it's called now, isn't it? DCIT should have is that digitization is not the same as innovation. If you have a company that digitizes, it is sometimes, firstly, not innovating, sometimes it's having its innovative ability restricted and constrained. And that is typically the case of working in the platform economy. If you agree to Microsoft terms and you agree to install the Microsoft suite and so on, your technological horizons are constrained by the tools that Microsoft have given you. And the way in which they want you to use those tools is designed to bring you further and further into this ecosystem. And it's designed to change your business task to match their business model. It is not designed to create a tool that matches your business. It is designed to change your business to match their business model. It is the opposite of innovation, where you kind of think people are going to have green shoots and flow and do something like strange and different, and then exist in a new niche, and then expand from that. And the training programs that are offered to AI and machine learning developers are effectively just to use Microsoft tools, Microsoft and Google and Amazon APIs to exist in this anti-innovative flow where British businesses, to use the terms of the British government, great British businesses sometimes, but never Northern Irish businesses, unfortunately, Jennifer. The great British businesses are appendages of these platforms where they are having value extracted out of them. And so a regulatory vision where Britain and its point in the global value chain is not as a technological appendage, but as something that is determining not only just creating new platforms, I don't mean that, but actually creating businesses which are doing weird and new things with technology that are against the grain of these big bureaucratic, slow-moving platform hyperscaler giants, which is what they are now, is going to be important to think and build into this proposal.
So I was gonna say very Dominic Cummings, getting some very weird new no, but I like very, very good point. Margot, we'll end with you.
Oh, I have no thoughts on it. Let's go to it would be nice to have any law.
All right, we'll end it there. I want to thank everyone for joining. Sorry that we couldn't get to everyone's questions, but I just want to thank you all for participating and for those in line as well. This will be recorded, made available on the UCL website fairly soon. And I want to thank you all, three of our panelists. Thank you so much for this wonderful and excellent discussion today. I think we didn't quite solve assessments and risk of any kind, but we've at least made some progress on what not to do. Thanks, everyone, and have a lovely rest of the evening.